Hi, everyone. Good evening. Carl Steinbeck here on a Friday night. Just want to cover what we had from a couple days ago. The Supreme Court of South Carolina issued its final opinion on the Alex Murdaugh double murder conviction. He was convicted of murdering both his wife and who was also the mother of their son, who was also murdered by him. He let one son survive, but he killed two of his family members. And the prosecution theory was this murder happened because what was unraveling in the law firm he worked at and was a partner of many years of was the fact that he'd been embezzling client funds for many years, and it was very egregious thievery going on, and the victims were very sympathetic, and it was really something that he was able to basically dupe the community, and including his law firm and people that they were like brothers to him and sisters to him, and he basically duped them all and was scamming them out of money, and that was all going to come crashing down on his head. So in his mind, he thought, well, I'll do a diversionary tactic, make myself the victim of some kind of invasion, robbery, murder type of thing, where my wife of many years and my loving son were murdered. Like, who would think of me in this small community as being capable of doing some heinous, vicious act like that? And so, in any event, the prosecution and the law enforcement folks did their job to uncover all the evidence, including what I thought was the most damning evidence in his case, which was the videotape that the son he murdered had him there with the dogs barking, and we heard his voice on there. And once I heard that in the trial, in the first few days of the trial, I realized this guy's going down, and there's no way he's going to come out unscathed. He also had the statement to the police that he was not there at the scene at all, but yet his voice on that video clip showed that he actually was there. So it was to me a slam dunk case. Also, all those suspicious things he did, and I won't relive all that now. But when I heard about this clerk issue, about the clerk tampering with the jury, I was like, this is bad news. And I thought, as much as I hate to say it, I think that in the interest of justice, and if you follow the Constitution, he's going to be granted a new trial by the Supreme Court. And what we saw the prosecution do was try to rehab this. And when they had a hearing and the jurors were questioned, to any of them that overheard this Rebecca Hill, the clerk of court, any of them that overheard things she said, it was several of them. It wasn't all of them that heard something that she had done. But all you have to do is tamper with one juror, and that can affect the whole outcome of the case. So I thought that when they had these different jurors testify, what we had was from Creighton Waters, the prosecutor. He was trying to minimize the statements, minimize the damage and effect of what Rebecca Hill had done to the jury. But I just thought that, you can't rehab this issue. You can't unskunk it. It's like the skunk urine that infected the jury box with what she did. You can't undo it. You can't fix it. You can't correct it. It just looks bad. And so based on that, as it turns out, we heard from jury arguments back in February, I believe it was, that it sounded like the Supreme Court was coming down really hard on Becky Hill as she goes by to her friends and locals there. So I think that once we look at this decision here, let me go ahead and go over some of the highlights of it, and then we can talk about specific excerpts of it. So in summary, to start out here, they reversed the denial of the motion for new trial that Harpootlian, that was the lead counsel, a local there in Columbia, the capital of South Carolina. And by the way, I used to be living in South Carolina, lived there for a year and a half. I was stationed at Fort Jackson. I was a senior defense counsel there. So I was doing court martials and any kind of adverse action for soldiers that were assigned there at Fort Jackson. And also went up to other places like Fort Bragg to handle criminal cases. But that was my main duty station. And it's a really nice place to live. Columbia's not too big a town, a couple 100,000. So That's where this court would be located. They also have University of South Carolina there. So the court went on to say that it's remanded for a new trial, and they determined that the Colleton County Clerk of Court, Rebecca Hill, engaged in improper external jury tampering. External meaning somebody outside the jury, so it's not somebody inside the jury room, one of the jurors that's doing something that's improper, but somebody outside their jury deliberations trying to affect something that's would happen inside the jury room there, which compromised Murdaugh's constitutional right to a fair trial by an impartial jury. So the Constitution of the United States guarantees the right to a fair and impartial jury. And this is like one of the bedrock things of the American justice system. We have the jury system, in fact, to prevent you from being convicted by somebody that works for the government. So the wonderful thing about American justice system is you don't have to worry about the politics of the judge, if the judge is against you, if the judge doesn't like you so much, because if you're going to be tried by a jury, these are people from the community that are randomly selected, should be randomly selected, I might add. And so, and they must, in most cases, have 12 on a felony, have 12 jurors that unanimously vote to convict. So here's what we have is the court applied the federal framework of Remmer versus United States. So they looked at federal case law to determine whether they decide, and established a three-part analysis for extrajudicial contact. And for the first one, it notes that it's the defendant's burden to show that the outside contact was more than an innocuous intervention. The court ruled that Murdaugh met this standard. There's a presumption in meeting the standard. It automatically triggers a rebuttable presumption of prejudice. So the state then has the burden to prove that there was not a reasonable possibility that the verdict was influenced, and that's a heavy burden. So the court found that Hill made highly improper comments to jurors before Murdaugh testified, including telling them that the day was epic or important and instructing them not to be fooled. So that affects the credibility of him as a defendant, not to be confused by the defense, extremely prejudicial. Once I heard that, I'm like, it's game over for the prosecution. Advising them to closely watch Murdaugh's body language. Because Hill was an elected official now and the primary caretaker of the jury, her comments carried immense weight and directly undermined the core of Murdaugh's defense. I totally agree with this. This is the way it should be looked at. The state failed to meet its heavy burden. You can't fix it, folks. That's the way it works. That's the way it works in American jurisprudence. The court also said that there was a misapplication of evidentiary rules by the post-trial court. So keep in mind, Judge Toll, the trial judge, who did a phenomenal job for the most part in this trial, a very likable judge that was hearing this case. Once this post-trial motion came in, he recused himself, and we had a different judge come in there to decide this. And they said that the court incorrectly placed the burden of proving actual prejudice on Murdaugh, the defense, rather than requiring the state to disprove it. And it also said there was a violation of the South Carolina Rule of Evidence 606B, that it improperly questioned jurors regarding whether Hill's comments actively influenced their minds or their deliberative processes. And the court said that under Rule 606B, the jurors may only testify on whether extraneous information was brought to their attention, not the psychological impact it had on their final vote. So they were asking jurors, like, well, did this affect you in any way? It's like, you know what? We don't get into that. It's not allowed. But the court allowed it, and then they did get some damaging information. But despite that, the court just really just ignored it and cherry picked the testimony, and they said, well, it's not significant enough to set aside the jury verdict. Also, there was something that I thought was troubling, was the financial crimes evidence. The amount of detail that Creighton Waters presented on the larceny, the theft of client funds and trust funds for the attorneys, for him as an attorney in that law firm was astronomical. I mean, he went over and over and over all these details, all these aggravating points, showing how he was just like a cold-hearted, cruel person. I remember there was somebody that was even handicapped, that he was just stealing funds from this person that was handicapped and had a major disability. So anyway, it was something that was really just piling it on, I thought. So hold on a second here. I lost my spot on this. Just a second. Don't want to show that just yet, but we'll get to that here. They have new screens here on StreamYard. That's what I use. And okay, so on the financial stuff, the court agreed that the evidence of Murdaugh's financial misdeeds was relevant under 401 to establish the state's theory of motive, that exposure was imminent and he was sought to buy time. Also, the scope and detail, the court unanimously held that the original trial court allowed the state to go far too long and far too deep into the inflammatory details of those crimes. For instance, detailing that he stole from a vulnerable adult with a disability carried a high potential for unfair prejudice while adding zero probative value to the motive theory. So that's what I understand why Creighton Waters didn't understand that this is like, you're like really raking this guy over the coals for something you haven't charged. If you want to go into that amount of detail, then charge the theft along with the murder. Then we have a mandate for remand. If the trial court chooses to admit financial crimes evidence during the retrial, the state must present it efficiently, stripping out unnecessary and highly prejudicial details. So, in conclusion, the court concluded that Hill's breathtaking and disgraceful effort to undermine the integrity of the justice system left them with no choice but to throw out the original convictions and order a new trial. So that's the nuts and bolts of it. And so let me go ahead and get this loaded on here. So I'm going to highlight some of the language here. If I can expand this out. So now let me make a full screen. Clint Adams, you're asking, could a private citizen or citizen file a civil suit against Becky to get her to pay for the last trial? Well, you know what? She's never going to have the money to pay it. And so, no, that wouldn't work. I mean, it could be part of her criminal case, the restitution for the damage she did, but I doubt they even pursued that. I'm not really following up on the details of that. I don't know if they actually pursued that or not. But yeah, doesn't that make sense that you cause all this heartache to the victims, you cause all this money to be expended to retry the case? They're probably going to have to change the jurisdiction of it now as well. So anyway, so here's what the opinion looks like. This is from their website. And so I'm just going to go through here. Here's what we see. The defense team consists of all of Columbia. Then we have the Attorney General, all the folks Attorney General for all these people are of Columbia. So that's where the Supreme Court is as well. Per curiam means it's basically unanimous. All of them agreed in unison. And look what they mentioned here for the 6 weeks early 2023, the eyes of the nation. In fact, a lot of the world, all the true crime followers around the world, descended on this Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife Maggie and son Paul. It said both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. I didn't really think it was complicated. It's pretty clear-cut. However, their efforts were in vain because the Colleton County Clerk of Court, Rebecca Hill, placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. And it says here, our justice system provides and demands that every person is entitled to a fair trial, which includes an impartial jury, untainted by external forces bent on influencing the jury towards a biased verdict. Although we were unaware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for a new trial due to Hill's improper external influence on the jury and ran for a new trial. because we order new trial, it's not necessary to review every evidentiary issue, but they do address the financial things, financial aspects. Don't need to cover all the procedural background. It does talk about the post-trial hearing in January of 24. And here's some of the questions about that the court says improper. They ask whether their verdict was influenced in any way by Hill. So the court should not have inquired into that. So here's one of the things that Juror X said. Looks like defendant's going to testify this important day. This is an epic day, and that was rare for a defendant to testify. Okay, so she's trying to do something to plant seeds in the minds of this juror. She says she did not impact the verdict, but you know what? The court's going to look at how does this look in the sense of justice when somebody's trying to comment on the defendant's testimony of that day. Juror Z submitted one of the affidavits. So this person was actually working with the defense to make an affidavit for the court. She said Juror Z responded that Hill said to watch his actions and watch him closely. In other words, don't believe him kind of thing is what I get from this. And they added that Hill said more but cannot remember anything else. And Juror Z explained that Hill's statements influenced her finding Murdaugh guilty because to me it felt like she made it seem like he was already guilty. And that state's request, the post-trial court questioned Juror Z about her affidavit addressing each paragraph in turn. So the defense sort of opened the door to this about how this affected Juror Z's vote. So that was something they should not have really put in there, I would submit. Juror Z's affidavit gave more detailed resuscitation of Hill's comments. Towards the end of the trial, after the President's Day break, but before Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Murdaugh's defense attorneys, which I understood to mean that Murdaugh would lie when he testifies. So here you got some clerk of court that is an arm of the court is basically saying he's a liar. Don't be fooled by him. And there's this, watch him closely, look at his actions, look at his movements, which I understood to mean he was guilty. That's just so bad, very bad. So that's the kind of stuff that should get any case in America tossed on appeal, reversed, busted on appeal, as I say. Also, she said that when jury deliberations began, Hill told the jury, this shouldn't take us long. Yeah, in other words, like slam dunk. You don't need to deliberate long. Just go ahead and convict him. That's what he is. He's guilty. I had questions about Murdaugh's guilt, but voted guilty because I felt pressured by other jurors. Okay, well, that kind of stuff is not as critical if that would have happened without this external influence. And after reviewing the affidavit, the post-trial judge questioned Juror Z. He said, I asked you previously, was your verdict on March 2nd influenced in any way by communications from Becky Hill, the clerk of court? You answered yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressure from other jurors. Is that now an answer? I just read more of an accurate statement how you felt. And the juror answered affirmatively. The post-trial court then asked if she stood by the affidavit. She said yes. And then she subsequently submitted an affidavit to clarify her testimony, which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of this record before the court. Juror P testified on the day Murdaugh was to take the stand. Hill made a comment to watch his body, so that was more corroboration of what we heard above. He denied Hill's comments influenced him in any way. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced in any other comments Hill made. Why aren't these jurors reporting this to the judge, I wonder? You think that's also something I think judges should be especially keen on when it's a highly publicized case like this, especially in a small town. People are going to do things really stupid and crazy, try to get attention. And sure enough, you're not going to expect the clerk of court to do something like that. But you got to be asking the jurors things like, has anybody talked to you? Anybody said something about the testimony? Just go into these kind of details. Any kind of these external influences. We hear things about, have you, heard anything from other people to talk about the case? You talk about facts about the case. But they need to be more explicit, I think, to prevent this kind of stuff. And these jurors who could have heard this kind of stuff, they could have been excused, and then they could have had alternates sit in, perhaps to save this from getting reversed on appeal. But even then, it's like this is probably an uphill battle to have the court not toss it. And then following jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments to jurors related, she made on the day Murdaugh testified, and with an earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She'll say she gave the jurors a little talk, instructing them to pay attention that it was a big day. She denied attempting to influence jury. When the prosecutor, Creighton Waters, called Hill as a witness, I just thought that, she should be arrested for what she's done. And he took her as she's telling the truth. And so I didn't believe her at all, what she was saying. In discussing her book, Behind the Doors of Closed Justice, The Murdaugh Murders, Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her, but she acknowledged as a true passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. As her book title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. Wow, that's pretty scathing there. I'm glad they mentioned that in this opinion. They also questioned Hill about the favors she granted the media, the post-trial court in that hearing. She said she denied allowing the press to review exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Although the post-trial court limited discussion of juror 785, when the trial court dismissed on the date of deliberations for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from juror 785's ex-husband. Hill claimed that juror was very talkative while Hill walked her to the trial chambers and volunteered that there were restraining orders on her ex-husband when they were divorced. In response to the post-trial questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters. And you don't talk to him about anything. She has to know that. It says here, in contrast to Hill's testimony, juror 75 averred to the hearing before the trial court in an affidavit Murdaugh attached to his motion for new trial that Hill interrogated her about the social media posts, whether she had been in contact with her ex-husband. In the affidavit, 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement questioned the ex-husband about the post, offering to reinstate restraining orders. 705 had against him and to speculate the murders probably got to the ex-husband when he called 75 and the juror 75 on the morning of the verdict. Juror 75 asserted Hill asked whether she and her other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. Wow, that's really damning. She also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's presented. I mean, this is so scathing of an indictment on the system down there. It's absolute corruption by this Becky Hill. Now look at this. This is how outrageous this becomes. Rhonda McElveen, she's a Barnwell County clerk who assisted Hill with the trial. So apparently she came from a neighboring county to help out. Testified that Hill reportedly told her she wanted to write a book so she could buy a lake house. I mean, talk about grifting, trampling on constitutional rights of a defendant just so you can make money. How disgusting is that? And a guilty verdict would be the best way to sell books. So that's why she was motivated to get these jurors to make sure there wasn't going to be a hung jury or a not guilty verdict. She testified that after Hill had given a juror a ride home, McElveen counseled her that it was inappropriate. And while Hill admitted that she gave the juror a ride, she claimed the bailiff was with them and they did not discuss the case. So you got a bailiff that's clueless enough, foolish enough to do something like that. And the bailiff doesn't report it to the judge. And here you got a deputy clerk that doesn't report it to the court. And this is like unbelievable. The amount of misconduct that's just allowed to go undisclosed to the prosecution or the court. And I don't know, would Waters have done something to get these jurors tossed? I don't know. I hope so. I believe so. The court certainly would have. Did they have enough alternates to survive it not being a complete mistrial? Although McElveen did not hear Hill say anything inappropriate to the jurors, she said that Hill made comments to her staff and media members strikingly similar to those jurors Z reported, such as advising him not to be fooled by Murdaugh's attorneys, to look at his actions and movements while he testified. And she also said that Hill seated a writer with court personnel, and this writer wrote the foreword for Hill's book. So talk about a sleazy type operation here. Then they also said that Murdaugh called the alternate juror to testify. She talked about, again, the defense is going to try to say things that will confuse you, don't let them confuse you or throw you off. I mean, it doesn't get more prejudicial than this. She said Hill told the jurors not to be nervous, don't show your emotions because that's what they want to see. I mean, what kind of a nutty operation is this? She says she heard a court member say the deliberation should not take too long. The post-trial court determined Hill's denial making these comments was not credible, finding Hill wrong to write a book, which she believed was a guilty verdict would help sell, and she was attracted by the siren call of celebrity, and that she allowed her desire for public attention of the moment to overcome her duty of oath of office and oath as a witness. Unbelievable. The post-trial court found that these statements did not affect jurors' verdict. It explained that jurors' assertion that Hill's comments affected her verdict were ambivalent, self-contradictory, not credible, emphasizing the jury had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors was a more accurate statement. So the second one he thought was more credible than the first. Anyway, it doesn't matter. There's enough damage there. So anyway, the trial court denied the defense motion. Here's where they do the law and analysis. And the state argues the jury convicted Murdaugh because he's obviously guilty, not because the jurors heard Hill's foolish and fleeting comments about his upcoming testimony. It contends the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. But as I said earlier, the court agreed with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. You can't overcome it. It's just so bad what she did. And it says here, citing another Fourth Circuit federal case, no right touches the heart of fairness in a trial than the right to an impartial jury. Well, think about it. What if she would have, as a clerk of court, the way it works in the United States, as a clerk of court, you're the one in charge of sending out notices to jurors that they have to appear for jury duty. So imagine if she would have not done this randomly and she would have like selected certain people or excluded certain people of who's going to get the jury notice. What if she would have sent it to people that she knows or friends of hers or her family, and just those people are going to be brought to court? Think about it, because jury selection, they're not asking who's related to the clerk of court. I've never heard of such a thing. The juries are asked on jury selection about, do they know the attorneys, the law firms, they had any dealings with any of these witnesses. They go down the list of witnesses, but they never asked about, hey, do you have, who do you know here in the courthouse? So this is a broad brushing question like that. It says here, this right can be infringed when a third party makes improper contact with a jury. For this right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced to trial. So she's introducing information, her opinion, and she's a sworn official of the court. So that's really egregious and prejudicial. And it goes on to state that in the Remmer decision, there's a rebuttable presumption of prejudice. It says here, any private communications, contact, or tampering directly or indirectly with the juror during a trial about the matter pending before the jury for obvious reasons deemed presumptively prejudicial if not made in pursuant to known rules of court and instructions and directions of the court made during the trial with full knowledge of the parties. So the parties didn't know this was going on. It was never brought to their attention. They could not cure it during the time before the verdict came out. The presumption is not conclusive, but the burden rests heavily on the government to establish, after notice to and hearing of the defendant, that such conduct of the jury was harmless to the defendant. No, this is not harmless. No way. And the Remmer decision also said that you're right, the defendant has a right to a hearing. And there's that 3-step test I talked about. I won't go through that again. Once the presumption is triggered, the heavy burden is such that there's no reasonable possibility that the verdict was affected by the contact. You can't say that in this case. Court must examine the entire picture, including the factual circumstances and impact of the jury. It just reeks of sick influence because she's trying to make money, make $1 million, write a book, get her lake home, dream home, vacation home to retire in, off of influencing a murder verdict. It's just unbelievable. Relevant factors to be considered, including outside influences, include how it affected the jury, including the number of jurors exposed, weight of evidence properly before the jury, and the likelihood that curative measures were effective in reducing the prejudice. The extent of the communication is the most important factor. And then it goes on and compares some other cases. It compares and contrasts other cases, and I won't go into that. This thing is 27 pages long, so we're only on page 12 here. Here, they give some examples. Finding a defendant was denied a right to a trial by impartial jury when 2 sheriff deputies who were key prosecution witnesses were responsible for the sequestration of the jury, during which time they ate with the jury, conversed with them, and did errands for them, even though there's no evidence of the deputies discussing the case with the jury. So it just looks bad, right? It doesn't look like you're getting a fair trial. So even though there's nothing said to compromise it, here you have extremely prejudicial comments made by her, an officer of the court. Here, another one in 2002, Fourth Circuit, holding defendant should have been afforded a hearing to determine whether a juror's husband repeatedly instructed her to vote for the death sentence would entitle the defendant to relief was proven. So here you got the husband of a juror pressuring her to vote for the death sentence. Another one, defendant was entitled to presumption of prejudice when his co-defendant attempted to bribe a juror and the state failed to rebut their presumption. Anyway, there's other examples here. And it just says basically follow the Fourth Circuit's 3-step analysis. The state tried to argue that the post-trial court implicitly rejected other comments as not being credible. So just those things like, oh, this is an important day, or this is an epic day, or watching his body language. Those aren't a big deal, and everything else is not credible. No, they're not going to believe that. They should know that the court is not going to just look at that as being not credible, because there's even more than one juror that said that. And they said even that the post-trial court found Hill's denial of making any inappropriate comments lacked credibility. The post-trial court made no distinction regarding comments or reference in its order and the remaining comments that are in the record. And they found credible jurors' affidavit statement concerning pressure from other jurors. And that's part of the thing that said not to be fooled. Watch Murdaugh closely, look at his actions, look at his movement. The state offers no rationale for finding part of the affidavit credible while rejecting portions that are damaging the state's case. Yeah, they're really trying to split hairs there, and you can't do that with the statement of the juror. Yeah, and they also say that Hill's attempt to insert herself in jury deliberations through these comments was in line with her state desire for a guilty verdict to sell more copies of the book she planned to write, her meddling in the events around Juror 75's dismissal, and her aggrandizing conduct throughout and after the trial, from granting favors to media members, such as allowing them to view sealed exhibits and sitting a writer with the court staff in the courtroom to granting interviews. As a post-trial court found, Hill was attracted by the siren call of celebrity and allowed her desire for public attention in the moment to overcome her duty to the oath of the court. Then I thought this was interesting here. Hill's lack of credibility during the hearing on Murdaugh's motion for new trial is further evidenced by her recent guilty plea to perjury stemming from the hearing for her denial of allowing members of the press to view the sealed exhibits. And we had no reason to find Hill did not make all these statements the jurors reported. Therefore, we hold Murdaugh established Hill made comments that day that the day Murdaugh testified it was epic or important and urged jurors not to be fooled, confused, or thrown off or convinced by Murdaugh to watch Murdaugh's body language closely. And then they look at whether these were more than innocuous interventions by her and of such character to reasonably draw into question the integrity of the verdict. Yeah, so the integrity is completely blown to bits of the system. Then they cite, these are similar to the Parker case rather than the Green case. Like the bailiff statements in Parker, Hill's comments attacked the defendant's character and credibility, which certainly were matters before the jury. See, Parker, that's a federal U.S. Supreme Court, reporting that a bailiff told jurors that wicked fellow petitioner, he is guilty. Same kind of thing here, saying that the credibility of witness is exclusively for the jury to decide. Hill became a character witness on behalf of the state, encouraging jurors in question to question Murdaugh's credibility. Well, even in American courts, you're not allowed to call a witness to say that another witness is a liar. So we don't have truth detectors here as witnesses. That's not done in courts. It's up to the jury to decide who's telling the truth or not. Then they cite some other cases in the analysis. I won't go into that. Then here's the Rule 606B. I talked about the South Carolina Rule of Evidence is limiting testimony a juror may give on the issue of prejudice. So I don't need to cite all this, but this here basically says you cannot testify as to any matter that's talked about the juror's mind or emotion as influencing them. So that was completely ignored by the post-trial court in reviewing the motion for new trial. They also talk about the U.S. Supreme Court has explained that rule as well. The federal rules are virtually the same. And there's some other argument here. The state is arguing. I don't need to go into that. I don't think that's helpful. And here's the part about financial crimes. All right. So at the time of the trial, Murdaugh had been accused of indicted for numerous federal crimes, financial crimes. But you know what? Those weren't for the jury of this case to decide. During the testimony for the jury, Murdaugh admitted he committed the financial crimes, although he had not at that time been convicted of anything. At trial, he pled guilty to the financial crimes. After trial, he pled guilty to financial crimes both state and federal court. So he was sentenced to a concurrent 27 years in state prisons and 47 years or 40 years in the federal prison. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive he committed the murders. And the state filed a pretrial motion arguing that the evidence demonstrated that he accrued substantial debts over a period of years, and to cover those debts, he engaged in illicit financial crimes involving theft and misappropriation of money from his clients and his own firm. And all this was going to really blow up the day of the murders. I remember hearing about that it's like the afternoon that was like starting to unravel when the firm was onto it. That's when the murders happened. And the state explained the motive theory, which is totally tracking with the real reality here. The murders serve as Murdaugh's means to shift the focus away from himself and to buy himself additional time to try and prevent his financial crimes from being uncovered. So he's going to try to pay all that back, stuff he had stolen, but he would never have been able to have that firm not call law enforcement to have him prosecuted for that. And then they talk about here that Murdaugh filed a memorandum arguing the financial crimes evidence should be excluded under relevance, 402, 403, 404B, under the rules of evidence. 403 has to do with the prejudicial impact outweighs the probative value. And in this case, the way he went into such details, I thought he was crossing a line, talking about the prosecutor. And I mean, it went on for a couple of days, as I remember. I was just really shocked that was going on so long. And they talk about here the 8 witnesses who testified outside the president's. Look at all these people, paralegals, bank folks, and consulting folks, attorneys in the firm, all talking about how he committed financial crimes numerous years, covering general categories, including all this right here. So clients, by billing personal expenses to them under the guise of expenses associated with their case, stole money from the law firm, instructed the law firm employees to make checks payable to Palmetto State Bank. And then the chief executive officer enabled Murdaugh to convert those funds for personal use. That Murdaugh stole money from his clients, and then had his law firm, and from his law firm by instructing the law firm employees to make checks payable to forge a fake account Murdaugh created to imitate a legitimate forged consulting firm that Murdaugh then deposited and used for personal expenses, and that Murdaugh stole the money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting insurance proceeds for personal use instead of giving the proceeds to Tony and Gloria's other son. I think that was the one that was disabled. So it made him look really, really bad to the jury, extremely prejudicial stuff. Now, if they would have charged him with that, then that's a different story. But 404B evidence, you're allowed to present other crimes, bad acts, etc., that a defendant has committed but not been convicted of in order to show things like modus operandi. Is there a common theme or some earmark identification or motive? That's another thing. So they went about it the right way. I just think they did too much. And then the court says, basically, evidence of other crimes, wrongs, acts may not be admitted to show the purpose of proving the character of the person in order to show acts in conformity with rules often say in terms of propensity. The propensity evidence admissible if it's offered to show some purpose other than to show the accused is a bad person or he acted in conformity with his other prior convictions. Another case they cite to shows that the state must show a logical connection between other crime and the crime charged. So as to the 403, that has to do with the prejudicial balancing effect. The court concluded that the potential unfair prejudice was not substantially outweighed the probative value. So it's more probative than it was prejudicial. As was discussed below, we find the considerable unfair prejudice in allowing the state to go as far and deep into detail as it did. However, we hold the trial court acted with its discretion in admitting some evidence of Murdaugh's financial crimes. Yeah, I've never seen that before, where you had that much focus on misconduct. There was a case I once had as a prosecutor that I had charged someone, and I gave 404B notice because the person had previously been acquitted of grooming and molesting neighborhood boys, went to trial, and in that other state of Massachusetts, he was found not guilty. And one of the ways he was able to get the jurors to find him not guilty was he had an expert that talked about suggestibility of children. And so this expert when he was being prosecuted by me to go for doing the same thing in Alabama, he wanted to bring in that same expert. So I gave notice under 404B, and I was calling in numerous children as witnesses, and I gave the list of witnesses who were going to be called to trial. But meanwhile, I got transferred. This is a military court-martial case. So meanwhile, I got transferred out of there to a different duty location. And so I had to give up the case to somebody else. And I told him, make sure, you get these other victims in there, because you will like significantly magnify both your chance of getting conviction and also getting a really large sentence out of it. So as it turns out, they did follow up on that. They did call these victims, and I remember they called some even in Colorado where I tracked them down. So they were able to call those witnesses, who are now several years older than when they went to trial the first time against this warrant officer. And as it turns out, the defense filed a last-minute motion to continue trial because they wanted to call the same defense expert, and they wound up not having his schedule aligned with the one the jury was supposed to happen. This trial was supposed to happen. So guess what? The judge says, sorry, we're going to trial whether you have your expert here or not. I'm not changing the trial date. And so that was busted on appeal. And so he got a 25-year sentence in the military court-martial system by a jury, and that thing got tossed. I don't know what happened on retrial, but it's like, wow, that was very upsetting to see. So anyway, this stuff goes to an example. You gotta bring in 404B evidence. It really is a help. It's like bringing extra ammunition to trial, where you can really gun down a defendant to show that this is not some one-off kind of thing, where this guy's got a great life as a outstanding human being, a great citizen of the community, but you got something out there that shows they're really a bad person. You got to bring in the 404B stuff, but you got to make sure you don't deny him a fair trial. So this one also here, Murdaugh was denied a fair trial, and so it was reversed and remanded. So they're trying to protect the constitutional rights of Murdaugh, even though they realize that Murdaugh is obviously guilty of this case. It's a legal framework you have to follow. If you don't follow it the right way and you prejudice the rights of a defendant, it should be a real stink on the justice system there in Colleton County. And they're going to have to redo it, and their defense is going to ask for a change of venue, like we saw in the Adelson prosecutions. In this case, they'll probably grant it. Maybe they should bring it to Columbia, the capital there. Maybe you won't have such chance of them screwing it up with all these folks trying to get their claim to fame by working on this case. So let me go ahead and get rid of this now and have a chance to look at your questions now. Here, Lori, you're asking, could Alex really be innocent, Carl? Well, he's presumed innocent by law, but I'm just telling you, based on the evidence presented, It's there's no way a jury's going to find him not guilty of this stuff. Trish, as you're saying, they all knew each other, small area, Becky and Alec. Yeah, I don't know if they knew each other, but there's a chance. So that's the thing. You got to really run a tight ship and make sure people are not doing stupid stuff like Becky did. Okay, Jordan Moore. I've heard about this case. Somebody I saw in the comments on one of my last live streams talk about this. I think this is the case. Letitia Stotch case, heinous crimes, but believe no choice but to overturn it. People not doing their jobs. And if a juror is acting out of line or they overhear some external influence, they need to report it to the court so it can be dealt with. This should not be done at the appellate level. That should be is the last stopgap measure, but this stuff should be fixed earlier. Yeah, so I guess the trial judge, he's retired. Let's see. This is not showing. All right, here we go. Yes, he'll still be found guilty. I don't care where they try this out. I just don't think that they're going to be able to find somebody that they can influence. Does Murdaugh have some pull if it was in the county that he lived in to be able to maybe get a juror to not vote guilty? I would say that's a chance, but they need to get it out of the area where this double murder happened. Yes, good point. Neverly, darling, you're saying greed got Alex where he is now, and Becky's greed got his conviction overturned. Yeah, it's a battle of greed. That's a great way to say it. Yeah, Hill's already been prosecuted, and she pled guilty. Joy Moore, this is already to the state Supreme Court, so the state cannot appeal it any higher. If the state had denied this, then the defense would have to go through federal court, done a habeas petition. So that was something they could do. But the state's done; they have to comply with this. They can't appeal it any higher. I notice there's different font now in the comments. It's not as easy to see for me, anyway. Maya Rodriguez Sorensen, how is this egregious behavior by Hill discovered? Did someone report her? Wasn't it a juror? I think what happened is, like in many cases, the defense goes and questions jurors to see how the deliberation process went. And that's how it probably came to light. And that's why they got one of the jurors to do an affidavit that the defense submitted with their motion for new trial. That's the way it normally works anyway. Laura, you're saying that they did say that on the defense, they had lots of new information. The prosecution knows a lot of it too. I don't evidence of what that's going to exonerate him and show that he didn't do it. I don't think that's possible. Yeah, Becky was charged. 6 months probation. I did not hear that. She should have done prison time. Yeah, so despite the fact that this guy is such a vicious killer, his case is overturned. He gets a new trial now. All this thing has to be retried. I've never seen a more egregious case of messing with a jury than this. Lori saying, it's disgusting what she did. It's corrupt, very harmful to defendants. This could happen to any one of us, Carl. Yeah. LMR, how will they get a new impartial jury now? They'll have to go to a different location. They'll have to send out jury notifications. They'll have to go through jury selection again. And I think they need to make sure that they're screening the jurors and advising them. The court needs to admonish them not to have contact with the outside folks. And if anybody tries to contact them or discuss the case with them, they need to report it, including anybody in the courtroom, including a bailiff, or they need to give examples like that. I don't think they're going to say this is on retrial because of misconduct by the clerk of court. I don't think they're going to go into that, but just generically talking about how they need to make sure that they're totally focused in, zeroed in, and if anybody attempts to manipulate the jury with outside influence or information. Jim, that's a good question. Do I think the state will offer Alex Murdaugh a deal, for example, 25 years to run concurrently with his 40-year federal sentence? No, I don't think that's going to happen because this is a double murder. I mean, this is extremely, extremely aggravating case. He deserves the death penalty, in my opinion. Maybe, Mac. Carl, do you think Alex will be stupid enough to testify again? Yes, I do. He's full of himself. Skier says Creighton Waters is going to do the trial again. I assume so. I think he's still around. I don't think he's old enough to retire, or I don't think he's moved on. Lamar, why do you think the jurors didn't report Hill to the judge? You know what? It happens all the time. It happens all the time. If there's misconduct, people just don't report it. In fact, like in the military, for example, on misconduct done, one of the briefings I gave to advise people on what the standards of discipline are and how people are getting their careers terminated by criminal misconduct when we're in a combat zone. And I would give examples of stuff we were prosecuting folks for. And I remember putting on the slide that one of the slides that, is junior enlisted folks that were reporting misconduct more than officers were. In fact, a lot of them were reporting misconduct by senior officers. So, a lot of people just look the other way, don't want to say anything. Well, it's not going to affect me, whatever. And so I just think they don't understand the significance of this and how this could cause a retrial. So I think if the judge gives examples, I think anytime a judge admonishes somebody, they need to explain why, give war stories, horror stories. So that's what I do anytime I'm given like briefings on military justice or standards of justice when I was in the military. I would give examples. Examples are the quickest way to wake people up. You go, wow, that's how people get in trouble. Okay. And I noticed a corresponding drop in crime as a result. So you just got to put people on notice what standards are better and give them examples. When you give them examples of how you can mess things up, people tend to follow procedure better. Now, somebody's saying 3 years probation is what she got. Let me go ahead and look this up here. Stand by a second. Let's see. Sentence. Let me look up sentence. You know what? I can't always trust Google or even AI search. A lot of those things are completely wrong. Stuff that's even simple that should not be subject to you getting hallucinations, as they call it, when you get bad information from AI. Here it says, she pled guilty to 4 charges in Colleton County Circuit Court. She was charged with obstruction of justice and perjury for showing photographs from sealed court exhibits from the Murdaugh case to a reporter and then lying about it in court, as well as 2 counts of misconduct for using her public office to promote a book she wrote on the trial and taking bonuses. She was sentenced to a year of probation. That is just shocking. Unbelievable that they would let her off that light. You know why I think they let her off that light? Because they didn't want to say it was such a big deal to affect this case. The more of a punishment she would have gotten, I think the prosecutors realized that the more this would help undermine their arguments to the court that, oh, it wasn't such a big deal of what she did wrong. So they used that to her advantage. If she'd have gotten the book thrown at her, which she deserved, then shoot, I think they're worried that would have helped the defense. So they went super light on her. Yeah, she did resign from her post, but yeah, scared. It's only 1 year from what I'm gathering here. Assuming I can trust this, but yeah, like my last coverage I did on Dr. Koenig when he still has his upcoming sentencing, but I did a AI search on what is a maximum sentence you can get for what he was convicted of, and it said 10 years. And lo and behold, I did search afterwards, and some of you pointed out as well. It's like, well, it's the statute. It talks about 20 years being the max. So that is correct. He's looking at 20 years max. So lo and behold, something simple as what is the maximum punishment on a certain statute, and AI can't even get it right. So unless I physically look it up myself, I'm not going to trust AI and something like that again. Yeah, Trish, I do hope to cover this on retrial. I did not cover it daily on that case. And I thought it was pretty much a slam dunk win. As soon as I saw that video of him down there with the dogs that his son happened to send to a friend of his right as he's being murdered, it was game over at that point. Yeah, John Smith. No, they're not going to go after Becky Hill to recoup the money. That would have to come on the criminal case. They don't give her probation. So they try to downplay this. And they're hoping that, there's not going to be a retrial. They're hoping the Supreme Court of South Carolina is not going to overturn this. But Supreme Court did the right thing. As much as I hate to see that when you get a heinous criminal like this. Same thing like Charlie Adelson. I hate to see if his case gets overturned, but I think there's a probability there his case will get overturned. So with that, I'm going to sign off here, and it's Friday night after midnight. So y'all have a great weekend. Be safe, and more stuff to follow down the future on other true crime cases. So be safe. Take care. Thanks for following Justice.